The initiative began actually quite a long time ago. It is an initiative by First Nations for First Nations. It's a unique legislative framework that is unique in Canada. There's nothing else like it. It began in the 1980s where a particular First Nation had some issues with the delegated program through Indigenous and Northern Affairs Canada. And they were anticipating that this new delegation would provide the First Nation with much more powers to be able to manage their own lands. And in fact, the program was discovered just to be more of a clerical type administrative work for the First Nation. And what occurred was the First Nation had a lessee who had defaulted on their lease and terminated the lease, and the lessee went to Canada, and Canada reinstated the lease. So that prompted the First Nation to take some action, and what resulted from that was a unique framework whereby the First Nations and Canada entered into a sectoral self-government agreement, which is the framework agreement on First Nation land management. And it took many years to get to the final product. So from the late 80s until 1996 in February, the agreement was signed between the initial 14 First Nations in Canada. It was an initiative that was probably something that most other First Nations were a little leery of, and that's why at first it was only 14 First Nations, and it was those First Nations that had that delegation of Sections 53 and 60 of the Indian Act. In regards to that time frame, the First Nations had to have at least 2 votes to ratify what's called the Land Code, which is the land law of the First Nations. So it's the governing, guiding principal document before Canada could ratify the Framework Agreement on First Nation Land Management with the act that ratified that document. So that was in 1998 when Musqueam First Nation and Scugog Island First Nation both voted and approved their land code. And that provided Canada with the ratification needed for their documents. So if you were to look at the framework of the legislative structure of this, the document at the top would be the Framework Agreement. And then Canada ratifies the Framework Agreement with their act, and the First Nation ratifies the Framework Agreement with their land code. So it is the Framework Agreement that is the principal guiding document. It is not like legislation, so the Canada cannot unilaterally amend the Framework Agreement. The Act must be consistent with the wording of the Framework Agreement. And we've had 5 modifications to the Framework Agreement since 1996. And all of those came about from improvements that the First Nations wanted to see in negotiations with Canada. And the First Nations have to vote and give directions to the Lands Advisory Board, which is the political body under the Framework Agreement that represents the First Nations. And so they vote on the document, on the modifications, and it really comes from experience and knowing what is not working with the Framework Agreement, so it's always an improvement to it. Once that's negotiated, once those modifications are done, and the Minister and the First Nations approve those, then Canada can go ahead and amend the Act to be consistent with the Framework Agreement. So it's very, very different. It is all about First Nations being in the driver's seat, and we continue to be in the driver's seat. So we've had some really, a lot of improvements since that time. As I said, Canada ratified the Framework Agreement, and they did that in June of 1999 with the enactment of the First Nation Land Management Act. There were 3 First Nations who had land codes by the time that the Act was signed. So we had 3 First Nations, Scugog Island, Georgina Island, and Musqueam First Nation, who enacted their land code as of January 1st, 2000, and that was very significant. Throughout the years, one of the amendments that we made to the Framework Agreement was to open it up to other First Nations. And currently we have 128 signatories, which is significant when you consider that there are only about 630 First Nations in Canada. And of those 128, we have 67 as of January this year who have ratified and enacted their land code. and 3 of those have actually gone on to broader self-government. So there is a process by which, because it is sectoral, you take on about 25% of the Indian Act no longer applies to you. So 32 to 34, depending on the First Nations sections of the Indian Act, just don't apply anymore. You opt out of the Indian Act. So it's about a quarter. And those First Nations then take on the legislative role, the jurisdiction, enforcement, environment, matrimonial property. Those are all the duties and the jurisdiction that those First Nations take on. So you can move from that type of sectoral self-government into broader self-government roles, and that has worked really well. Westbank First Nation was the first Nation to do so, and their land code works so well that actually, if you take a look at their constitution, the land code section, or the lands management section, is their land code. So in order for Canada to move forward with ratifying the Framework Agreement on First Nation land management, they required that 2 First Nations go to a vote and ratify the Framework Agreement by passing their land code. And so Musqueam First Nation and Georgina Island First Nation went to a vote in 1998 and ratified their land code, and that allowed Canada to then be able to ratify their portion of it through the Act. And so that set up the process for that. In 1996, when the First Nation and the Minister approved the Framework Agreement on First Nation land management, there had to be a component to it where Canada's roles and responsibilities and obligations were going to be outlined, and that is that had resulted in the First Nation Land Management Act, which was put through Parliament in June of 1999. And so that document really just outlines Canada's role in all of this. It's a little bit more of a technical document, not too much in regards to how the First Nation does things, but really in regards to how Canada meets their obligation under the Framework Agreement. And it must be consistent with the wording of the Framework Agreement, because that is the agreement that's in the hands of the First Nations and the Minister and negotiated as a government-to-government agreement. And so far we have really seen that support by the government in regards to the different, whether it be conservative or liberal, it doesn't really matter which government we have been dealing with. We have seen that they are supportive of this throughout the negotiations of the initial framework agreement, through the enactment of the First Nation Land Management Act, and throughout the process where we've made amendments to the framework agreement, where we've added First Nations. We are in the process of adding First Nations currently. So that process is always ongoing, and the results, the facts, the data support that First Nations are ready to take on or return to, because we're reassuming this is not something new. We've always been the stewards of our land. We've always been business people. And so we're just going back to what we've always done before the Indian Act was imposed on us. And the results are astounding. KPMG did a study in 1998, and it was released in 1999, I believe. And subsequently, they've done another study as well. And the data from that demonstrates that Canada is not giving a handout to these First Nations. For every dollar that Canada invests in Land Code First Nations, at least 10 is going out into the Canadian economy through job creation, through taxes, through leakage, through to the outside community. And so we're becoming regional players and not just players at the local level. And we're not just helping out our band members. That's the main reason we get into this. But the statistics show that on a regional level, the results are just astounding. We have Whitecap Dakota First Nation, which is in Saskatchewan. They're just south of Saskatoon. And they only have about 250 people living on reserve. And that includes members and non-band members. However, since their land code has come into place, they've created over 700 jobs, which means they have to import employees. And so now they're faced with a situation where they're anticipating another 500 jobs being created in the next few years through some of their other ventures. And what that will result in is a shortage of housing. So they've addressed that, and they're continuing to address that, as well as improvements to the infrastructure, improvements to the housing, improvements to the services, internet, communications, and all of those kinds of things are being looked at. And so not only now are they players on reserve, but they're also being asked to participate in the city of Saskatchewan. They're participating in a school that has programming now for Indigenous children that's based on culture, and so that's a new school that Whitecap Dakota is really integral in establishing. So we're seeing that culturally, infrastructure, in other areas of quality of life of our band members, that is where we're seeing the most impact now because of the fact that First Nations are making those decisions at the local level. So through this process, as I indicated, the First Nation ratifies the framework agreement by enacting a land code. The land code is the basic principal document that is the founding land law of any First Nation under the framework agreement. It allows the First Nation to be able to resume control over jurisdiction, legislation, environmental protection. It fills legislative gaps such as the matrimonial real property on reserve. Most people are not aware that there is no law, or there wasn't any laws on reserve to address when there was a breakdown in a marriage. The land code was the first document that addressed that. So it's really about putting the First Nation back in control. Now, this document is something that the band members are required to ratify in a vote. So there is a referendum. As a basic principle, the land code is a grassroots effort. Usually a committee of band members will develop and draft the document. There is a lot of community engagement, whether that be community meetings, whether that be online videos, whether that be e-voting, which is a huge component to this, because there is a requirement by every First Nation to try and locate and inform their members so that every band member can have the opportunity to vote. And with that, it requires that they try to locate all of their band membership. And that's kind of a monumental task, especially for Eastern First Nations or some First Nations in the prairies, where we actually have First Nations that have 6,000 or 8,000 band members. And having to locate them and inform them is quite a task. So e-voting has been something that we've embraced. Under the Indigenous and Northern Affairs programs, First Nations can't do that for referendums under the Indian Act or for elections. However, the framework agreement states that every First Nation can develop their own community ratification process. So that allows a lot more flexibility, and with a lot more flexibility allows for a lot more ingenuity as far as how we do things. And that's the other component of this, is that once you have a land code in place, we've come up with a lot of imaginative, innovative ways of moving forward with the land code and our land laws and policies and procedures. So e-voting is definitely one of them, and they continue to do that once their land code is in place. Because it is in the hands of the First Nation, it is now in the hands of the band members. So there is no more reporting to INAC on your day-to-day administration, management, governance of your land code and land-related activities. You report to your band members on an annual basis. Most First Nations do it through the newsletter as well, so it's not just an annual thing, but it's an ongoing, transparent process. The process is also one by which the First Nations are involved in the drafting of the land laws, and in some cases actually voting on the land laws or land issues. And it's a very clear process. The conflict of interest rules are very clear. There is an alternative dispute resolution process, which has been integral to actually attracting corporate partners, where they're assured that there is a process by which, if they have a disagreement with their landlord, which is the First Nation, then there is a process that is clear, defined, where they can seek to resolve any conflict with council, or in some cases it could be between two neighbors, or so those avenues are there where they haven't been in the past. The Land Code also provides the First Nation with the ability to legislate, which is something under the Indian Act that you just really can't do adequately. Under the Indian Act, First Nations can only enact bylaws, and they're very hard to enforce because then they become federal laws. Whereas under a land code, the punishment fits the crime. So it's a lot more equitable. So if you have somebody driving an ATV where they're not supposed to, which is one of the first land laws that Nipissing First Nation enacted through necessity as opposed to planning. Just everybody was going around with their ATV wherever, and we needed a way of being able to control that. And so the process is a lot more equitable. It's based on a fine. The Anishinaabe Police, who is our local police force, will actually ticket the person who's doing the infraction, and the fines are then remitted to the First Nation. The other thing is that we are able to hold court in our local jurisdiction, and not at the request of the person who's doing the infraction, but at the First Nations local level. We are able to now appoint justice of the peace, work with the local prosecutors, and have those laws looked at as actual laws and not bylaws under the Indian Act. So although enforcement is always going to be an issue, it's an issue in every jurisdiction. If it wasn't an issue, we wouldn't have anybody in jail. There would be no fines. All the traffic would be flowing, smoothly. So it's always going to be an issue. And I think that with a land code, sometimes the resistance is from the local population, those people that live on reserve, because there's a lot of change. There's no doubt about it. Taking on lands management is, for some First Nations, a very, very risky thing, because then you're not, you don't have INAC there to step in. Whether or not that's been effective in the past is not something that we can say that has been effective, but it's always been there for quite a long time. So we've gotten used to that. So to step away from that and take on that responsibility is very, very challenging. I get asked a lot, have there been any negatives? And we can honestly say that there has been no negatives. Challenges, yes. I always tell First Nations that the easiest thing they're going to do is develop and enact their land code. Everything that comes after that is where the challenges lie, where the bulk of the work is. You're buying yourself at least 100 years worth of work, and that can be overwhelming. But the Lands Advisory Board, as I said, is the political body, and they've established the organization that I work for, which is the First Nation Lands Management Resource Center. And so we are there to assist and provide technical support and assist the First Nation with going through, when they're interested in learning more about the framework agreement, as they're going through the adhesion and becoming signatories to the framework agreement, and then through the developmental process of putting their land code into place. And our services continue once they become operational First Nations. And so we've amassed a lot of the documents, the land laws, the policies, the procedures, the forms, the leases, the certificates of possession, or the certificate of interest, or whatever it is that the First Nation calls them. And we amass all of that as models, and so our role continues through the entire process. And not only that, but each First Nation that comes before us provides a lot of information and a lot of support to each of the other First Nations. And so we've seen that it's a really tight-knit group, and we meet at least once a year And then regionally, we may meet 3-4 times a year with the First Nations. And there's a lot of sharing of information. And I think First Nations have always helped each other out. And so it's nice to see that aspect of it as well. And so we're really seeing now that as a group, they're really moving forward with the environmental protection. They're really moving forward with economic development. We've seen that although there are challenges, the benefits can also be seen fairly quickly. We have Magnetawan First Nation along Highway 69 here in Ontario, and they voted on their land code in the summer of 2015. And one of the first things they did, because they're along that corridor where there's not a lot of service stations and not a lot of places to stop to get a coffee or have a rest, they've now converted their existing gas bar into a Tim Hortons and service station, which is going to be opening in about a week or so. And that's fantastic, because otherwise they would have had to go through the INAC process, which is a very long and drawn-out process. You have to designate the land, you'll have to have a community vote, and then INAC negotiates a lease on your behalf. And you're actually not at the table. They negotiate on your behalf because you're a ward of the crowd, basically, and you're not independent. However, through this process, the First Nation did enter into negotiations with Tim Hortons themselves, and so it's at the speed of business, and we're really, really seeing the benefits of that. And so this will create some jobs locally. It's a smaller First Nation. The other exciting thing for that First Nation in particular, and all of the other First Nations, is that Canada has very, very restrictive expropriation rights. And when it comes to land code First Nations, we don't anticipate that there would be conditions under which Canada would be able to meet all of those conditions if ever they were to move forward. The other thing is that there is no expropriation at all by the province or municipalities. So it's a new reality for the Ministry of Transportation, whereas they are trying to widen Highway 69 to a divided 4-lane highway. And if you drive from Sudbury to Toronto, you can tell when you've come to a First Nation. Henvey Inlet First Nation is the first First Nation that you'll encounter on your drive, and you're going to be going along, and it's a divided 4-lane highway, and then all of a sudden you go to 2 lanes. Then you go through Henvey Inlet First Nation, you go through Magnetawan First Nation, and you go through Shawniga First Nation. And all of those First Nation have land codes in place now. So it is a different mindset for the province to negotiate with these First Nations. And because they cannot expropriate the land, it now becomes, what does the First Nation want? And so that's where we're starting, the starting point is for the negotiations. And whether that be an exchange of land, or whether that be a lease or some type of other instrument, it's up to each individual First Nation to negotiate that. Well, the Indian Act was imposed on First Nations, 150 years ago or so. It is a one-size-fits-all. First Nations don't really have a say in the policies that are developed under the Indian Act. For instance, the Indian Land Registry System is a system where the lands that are under the management of Indigenous and Northern Affairs under the Indian Act are prescribed through processes and policies that Canada amends as they go along. And once they've amended those policies, then they inform the First Nation of how things are going to get done, what type of forms are to be used, and forms are all the same. Whereas under the Framework Agreement on First Nation Land Management, we have developed regulations, which are federal laws, to regulate the First Nation Land Registry System, which is a subset of the Indian Land Registry, but it is in the control of the First Nations. So the First Nation can develop their own instruments, they can develop their own policies, their own laws on how and what gets registered, and they can then upload the document to the registry. So it is instant, it's paperless. Canada does not verify that the documents are done. They don't approve them. The First Nations are the ones that approve them. So it really is in the hands of the First Nation. The other thing is that we develop the regulations in conjunction with financial institutions. So what people don't realize, and there's a lot of confusion as to why First Nations can't build houses. Why is there this disconnect between the standards of houses being built on reserve? Why is there a disconnect between the level of safety in houses? Well, the reason for that is that there's very little opportunities for band members to get a mortgage on reserve. Usually it's through a CMHC mortgage, and it's for a very limited amount. So you can't build to the building standards that you would like, especially in certain conditions and winter conditions and those kinds of things. However, under the framework agreement, you're able to be very imaginative when it comes to mortgages. And so now those mortgages can be registered and can have priority in the registry, just like you would with any other land registry. And so that provides the lender with assurances that they'll be able to, if there is a default, which under the framework agreement, under a land code, the default rate is actually very, very low. Because band members, we live in these communities. It's not like we're going to be moving out. They're vetted by the First Nation and they're vetted by the banks, just like you would off reserve. And so there is almost zero risk to the First Nations to taking on mortgages. The other thing about the regulations is that, again, if there are amendments to it, it will again come from First Nations and from negotiations. So it's still in the hands of the First Nations. The other thing too is that the Indian Act provides some protection, and we can take on more sections of the Indian Act as we proceed. So under the framework agreement, First Nations are recognized as governments with full legislative power and their ability to have their laws recognized by a court of competent jurisdiction. So that aspect of it is empowering those First Nations to move forward with implementing legislation, laws, and policies and procedures, codes, building codes, which are non-existent right now. So it is really about the First Nations being able to put processes in place that will govern for a long time. So the framework agreement also allows for a lot more flexibility. The innovations that the First Nations can put into place is really only limited by their imagination. Whereas under the Indian Act, it's one set of rules for all First Nations, and it's very, very difficult to be able to do anything that's innovative if you're going to be following those rules. Some First Nations may not follow the rules, but if you're developing the rules for yourself, then the First Nations will follow their own set of rules. Under the Indian Act, the reporting, the accountability, the decision-making is all with the minister. Whereas under the framework agreement, the accountability flows to the membership and not the other way around, which is always how we've done things in the past. So we're just going back to that and empowering our band members to participate actively in the governance of our lands and resources. So they're integral in our engagement when we're developing policies and procedures for the environment, for environmental assessment, for the species at risk, for what type of businesses are going to be put into place at the First Nation level. The other thing is that band members themselves are growing the economy at our First Nations. So if you take a look at Nipissing First Nation, which is the First Nation that I'm from, we voted on our land code in 2003. Sorry, we voted on our land code in 2003. And since then, we've seen the growth in the opportunities that our band members are going after in economic development. So we've created a very, very stable and diverse economy based on the investments of our own band members. And we provide them with an opportunity to be able to compete with other local businesses by allowing them to have land that is leased and then be able to access conventional financing, whether it be through the bank or through government programs for businesses. They're able to do that and do so successfully. So we've seen a huge range of different types of businesses, everything from law offices to IT companies, and of course retailers and so forth. And what that has created at Nipissing is that we are an equal opportunity employer. So our band members employ about 300 or so employees, and a third of them are band members, a third are band members from other First Nations, and a third are non-band members. So it is, again, about being a regional player, and so we are recognized by the local municipalities, and they have been integral also for the support that our First Nations, as they move forward with their economic development, because what's good for one community is good for all the communities in the region. So those are things that you really can't do under the Indian Act, is to be able to provide those opportunities without having to go through the bureaucratic processes of designation, of going through the lease process or the negotiations between Canada and the individual land interest holders. So that really provides the catalyst for our band members to take that pride and be able to do something with it. And so we're really proud of that as well. So we have talked a little bit about it through the other segments, but I think that for some of our First Nations, the speed at which they can do business, they can make decisions locally, is really something that has provided them with the quick response needed in this day and age to be able to proceed with projects. So Doki's First Nation had a large-scale hydro project that they had been working on under the Indian Act until their land code came into place. And the difference between having to go through the bureaucratic process under the Indian Act to post land code was just phenomenal for this First Nation. And so now their project is on the ground, it's operational, and the revenue and the other opportunities that they've that are consequential to having this power plant has resulted in a community already moving forward with other projects and being able to provide mechanism to address other issues in the community that may not be land related, as culture and history and those kinds of things. So they've also developed a building. They built a new lands department building, and so we're seeing a lot of improvements in those areas. One of the most developed First Nation as far as economic development is West Bank First Nation out in Kelowna, BC. And they now have over 400 businesses located on reserve. Every major bank has one or more branch on their reserve lands. They have the largest population of non-band members living on reserve in all of Canada. They have about 9,000 non-band members living on reserve. And all of those are paying leases and paying property taxes to the First Nation, although I have to clarify that property taxes is not one of the sections that the First Nation opts out of. That section is still there, and the First Nation can always access the ability to be able to put in a property tax regime in place. But they just, for some First Nations, they work very well together. And so that First Nation is now also seeing other projects being implemented in the region. They are partnership in a golf course that's off reserve. So regionally, that First Nation is also really a huge player in the local economy. We also have Scugog First Nation, which is a small First Nation in the area of north of Toronto, between Toronto and Orillia. And this is a very tiny First Nation that doesn't actually have a lot of land transactions, but they are the largest employer in the region. And so it is phenomenal once a First Nation gets a land code in place since January 1st, 2000, how they, once they have control in their hands, that they are able to proceed with economic development and other projects where they're not seen as, they're seen as a major player and not just a First Nation. Success is measured by what your goals are. And so I get asked a lot about what happens to those First Nations that may be more remote or smaller or may not have access to the larger urban centers. I think that when you look at some of the smaller First Nations and what their goals are for land management, land governance under a land code, take Laidley Tene in British Columbia, for instance. What they really wanted to do was protect their forestry industry and be able to have a sustainable, long-term economic benefits from their forestry, and they were able to achieve that. So for them, the land code really met their goals, and they achieved those goals. And subsequent to that, they've actually been recognized by the region again as huge partners, and they were the First Nation host for the Canadian Winter Games a few years ago. So again, just by being able to make those decisions at the regional level, the impact of land governance is just remarkable, and within such a short time frame relative to the Indian Act, we can really say that the land code has benefited and been a real huge success story for our First Nations. We have 68 communities that have ratified their land code. Every year we have many other communities going to a vote, so it's always a changing number, so it's always a little difficult to keep up with the stats. But here in Ontario, we have 11 First Nations now that have land codes, and all of them have achieved huge successes as far as land governance. Georgina Island, which is an island, have since been able to acquire a new ferry to get to the island. Although it's in a more urban area, close to Orillia, close to Barrie and Toronto, they're still considered a smaller, remote First Nation because of the difficulty of getting to the island. However, they may not have been seen as an ideal candidate for land governance under the framework agreement, but it is remarkable what this First Nation has done as far as land leasing, as far as economic development. They have just completed the construction of a new restaurant and office complex just on the main shoreline of the lake because of the ferry docking. And so again, may not have been an ideal candidate in the eyes of Indigenous and Northern Affairs, but with jurisdiction and control at the First Nation level, it just demonstrates again that we as First Nation have always known what we can accomplish. And to have the regions, to have Canada and the world recognize that is just astounding. Again, in the 20-some years since the framework agreement has been put into place, and for the 17 years that we've been in operation. So those little stories are not little stories. They're actually huge success stories for First Nations people, and you know, I'm just actually really proud to be working in this, and it's quite fulfilling to work in with these First Nations and have all of these First Nations move on and take control and just demonstrate what again, what we as First Nation have always known what we can accomplish.